Welcome, everyone, and thanks for attending both online as well as in person. We wanted to talk a little bit about Apple and Epic, and in particularly that case. But I thought it might be helpful to give you a little bit of just background on some of Apple's legal issues outside of the Epic trial. We'll dive into the Epic one, but and in particular the antitrust implications here in the United States. But I wanted to point out that there are antitrust inquiries into Apple's business practices around the world. And I was just reading this morning that the KFTC, the Korean Free Trade Commission, has an order against Apple and Google about opening its app stores and not mandating in-app purchases, and to submit a compliance document in the next month. That just came out this morning. And so these sorts of issues are happening for Apple all around the world. Apple is on the other end, and you'll hear some of the arguments that Apple's making in the Epic case. Apple's in a patent infringement suit against a company called Optus in the UK, and is threatening to leave the UK market if rates are set along standards essential patents that the UK court may set worldwide. And so I think that's what I'll see as a bit of a contrast is I think the arguments that Apple's making in the UK court are contrary to the arguments that Apple's making in the Epic trial. So we'll talk about Epic more specifically, then we can circle back around again on the consistency of those arguments around. But let me hand it over to Bill, and we'll start there.
I'll try to get this back on, and I push this button. I think that's what I'm supposed to do. Let me just start with something. Those of you taking copyright, this has nothing to do with antitrust, but this little video is what sort of kicked off the battle between Epic and Apple. And this is a parody of a very famous Apple ad in 1984 when they were challenging Microsoft's position as the dominant OS manufacturer. So you might think, okay, you're the lawyer for Epic, and they say, we're going to show this thing. Clearly, it is based on some other copyrighted work. What do you have to think about? This video shows up something I'd like to get to at the end. Oftentimes, these business antitrust cases are about money, and it's about, what does each party want? And once, the antitrust things play out a little bit, like, oh, you've been non-suited, or you've been, asked to participate in a certain way that you're going to get a certain treatment, then the parties know what the risks are a little bit better, and usually they settle. This one seems to have gotten personal. I'm not sure why. I've got a couple of emails and some exchanges from last week or a couple of weeks ago between the CEO of Epic and the senior vice president of Apple, and he didn't respond. The senior vice president of Apple, and they've just knocked Fortnite off, even though they've agreed to comply with all the rules and paid up the fine that was in the decision. So this is going to probably go to the appeal, not probably settle out as far as I can see. And part of it you can see by, this is how they kicked it off. And I'm sure this got Apple's attention when they showed this, this ad, essentially evading Apple's attack on Microsoft years and years and years ago. So AJ will now let you see what you're supposed to do.
Celebrate the anniversary of the platform unification directives. For years they have given us their songs, their labor, their dreams. In exchange, we have taken our tribute, our profits, our control. This power is ours and ours alone. We shall prevail.
Okay, so that's how this whole thing kicked off. And we ended up having a antitrust complaint filed shortly thereafter. I think it was maybe even the same day. And the antitrust complaint was really about not letting Fortnite get its payment system through another way. They're paying 30% for people buying things in the game. And 80% of the money coming through that app store or from people buying these little extras in all these games. So it becomes a very important industry for these people. So the complaint's filed, and we get a pretty quick trial and opinion. The trial happened in May. And think about it. I mean, you've got the CEO of Apple spending a significant amount of time. You have depositions, you have many lawyers. How much money does this cost just to get to this point? And then we get an opinion by Judge Rogers in September of 2021. And the judge in the Northern District of California delivered a ruling in a 185-page opinion. These things are not small. And the interesting thing I found is the next day, people were reporting. So obviously the reporters were out there reading it. And you would have had a little bit of schizophrenia when you were reading the headlines. If you were reading CNN Business, huge blow to Apple, did Epic win? And then if you looked at Politico, Apple wins the case. So, it's like, what's going on here? Well, it was a bit of a mixed opinion, but I always like to look how the stock market votes. These are both, these industries are publicly traded industries. So investors decide, how much is this going to affect the future cash flows of either of these companies? And Apple took a huge hit. If we look at that, Bloomberg calculated it 85 billion. I think that's a little much because a lot of it's, Me Too trading. If things start going down, people follow it down. But after the ruling came out, it did take a precipitous drop. And at the same time, not Epic, but gaming stocks started soaring because people thought, hey, it looks like this is going to loosen up. And I think with Micky, pointing out that South Korea, Japan, all of these countries are now sort of piling on the same thing. What's Apple going to do? Have a different rule for each country? Probably not. We're probably going to see a global loosening of this lock-in payment system. And I think this is an important, this is an important article that came out in the middle of the summer. And we always throw around this idea that they're monopolies. Oh, the Facebook monopoly, the Apple monopoly. And I think this is a good question to ask. This is what the court had to figure out and didn't come to the conclusion that most of the public would have come to. It's monopoly of what? What are we talking about? And I think Judge Rogers got it correct when she said, what, central to all of this is what's what we call the relevant market in antitrust. Now, just for those of you who haven't taken antitrust in this country, the relevant market has two parts. And one's the product, and the other part's geographic. So, wow, this jumps. So you have to decide what's the product, and then what's the geographic market. And particularly when we're doing what we call a Sherman 2 case, I have two elements I have to show. I have to show monopoly power in a relevant market, plus then some monopolizing activity. I don't get to the monopolizing activity unless you tell me what the market is. And so we have to figure that out. And that becomes a big issue in this Epic case. What is the relevant market? Now, each of them had their own opinion. Epic said, well, it's Apple's own system. They essentially defined it by the iOS App Store. And if you look at this, yeah, it's clearly Apple has a monopoly. They're the only one in this market. Now, Apple proposed a different market, all digital video game transactions, which would be huge. I mean, there's a lot of other ways that you can get your games other than go through the Apple Store. In fact, a lot of games aren't on Apple even. More PC games than there are Apple games. So you probably were a lot of people using those other systems. Now, the thing to always remember, though, is Epic Games, as the plaintiff, has the burden. Apple didn't have to prove anything. They're trying to disprove what Epic says. So they have the burden. Now, the interesting thing is the judge comes out and says, you know what, neither you're right. By looking at the evidence, I think the market is something different. Digital, mobile, gaming transactions. And the word transactions is important because that shows she's analyzing this as a two-sided market, that they're sitting in the middle between something happening, a transaction. They're the platform between the app makers and the people buying those apps. So she says, I think that's what it is. And I assume this will be part of the appeal. Now, did she get it right?
Can we debate that point for a moment?
Yeah, sure, go ahead.
Okay. So this is the reason I think Apple won, right? Because when I think of the Apple App Store and a 30% fee, and Spotify, for example, is battling the same argument against Apple, both in the US and in Europe. Apple gives discounts to Netflix for its apps. Netflix doesn't have to pay 30%. They've got a separate bilateral.
Yeah, in fact,
I hope maybe you're.
I'm going to get to, no, I'll pull it up now. You can talk about it because I think that's an important point, what they call the reading apps.
So I think Judge Rogers got it wrong. I don't see how an Apple, a store with a 30% fee is somehow limited to this when you have sort of disputes going on in Spotify, which is completely separate from this. You've got video distribution, you have other sets of developers. To me, this is an overly narrowing of the market, particularly when you look at some of the other international cases going on, where it's not just Apple, they're looking at the Google system as well as an app store and the protectiveness around this. I think Bill's absolutely right when he says it's about the stock market reaction. I think the immediate reaction of the market.
They're losing money.
And then it reversed. But mainly because I guess it was about 3 years ago, Apple stopped reporting iPhone 6. They did that intentionally, right? Because the smartphone market sort of grew through, and then it's somewhat saturated. And the PE ratio that Wall Street often gives to product companies is much, much lower than it does for recurring service revenue types of companies, software companies. So Microsoft or Google or Amazon have that sort of astronomical PE ratios because of that level of recurring revenue. 30% App Store is recurring revenue, right? It gives you that level of recurring revenue. You get that extra multiple. So by sufficiently narrowing the scope of what they defined as the market, they still get to collect their 30% on every app out there. You mentioned the worldwide piece, which I thought was
and that's why I brought up because what Micky's talking about are what they call reader apps. These certain people already have, like Netflix and Spotify, have this, a different deal, and they call them reader apps. And the question is, will it go to total? Everybody's going to be a reader app, or is it just going to be reader apps globally? Apple's already announced sometime in 2022, I guess they're going to go all reader apps globally.
Yeah.
But will they expand it more? And that's going to be an interesting question.
It's hard to say. And I'll say I have some personal experience here. You pay for the right for that real estate to be that reader app. And I have experience in this in the Android system. Like if you want to deal with Samsung and want to have those downloaded apps kind of at the first time, you're paying for that. You're paying billions of dollars to be that download, that pre-installed application on it. And so that's another piece to this. It's like the revenue stream in terms of what Apple would be getting, maybe getting less in terms of a cut from the 30%, but on the other hand, they're getting a direct payment by being directly on there in the first place. So I think the money's a bit of a wash. I just want to talk briefly about market share because you mentioned, Apple only has about 20% of worldwide market share, but it has 50% of the US and it's 80% of Japan. So it's an uneven landscape around the world. So I do think we'll see sort of different rulings in different parts of the world based on that level of market.
And then whether or not Apple is going to have Apple Japan, and then they'll have to have a geo lock to figure out you're not using the VPN to come in and pretend you're in Japan. So people are clever. They'll figure out ways.
Probably.
This is how I watch the BBC. Use my VPN. Pretend I'm in Britain. Okay, so this whole area of antitrust is a real problem for the digital age. When we had commodity products, your cars or something, it was pretty easy to figure out what the market is. And we looked at this idea of reasonable cross-elasticity demand. We had a lot of ways of doing it. And in fact, if you look at the horizontal merger guidelines, this is how we do it. and we figure out the SNP. But a lot of this doesn't work very well in the digital age, trying to use these techniques and make the models. And if some of the reasons for it are very clear. Now, one of the problems is this one. What's the geographic? Apple asserted a domestic market and the other half of the relevant market, and Epic said global. And on this point, actually, Epic wins the debate. Judge Rogers says it's global. Can you imagine trying to do discovery now where your market's global? I mean, your costs just went to the moon. I mean, it's like you're getting translations, and are those translations correct? And you're trying to do discovery all over the world. This complicates it. And I think a lot of these things, it might be global unless you can kind of cut it up and stop it from being global. But she's essentially told them, this is a global market, so my discovery can go a little wider than perhaps I want it to go.
But I also think that's relevant in the sense that Apple's worldwide market share, again, is 20%, not 50% as in the United States, which buttresses the argument.
Yeah, so there'll be even less so. I think she figured out something. And here's what she ended up with her market share out of what she thought. And she said 55%. But this whole thing is not easy to determine what is the market and where are the boundaries of it. And I think she's right, because there really wasn't much evidence on what is this global market. So if it does come out to be much lower. One of the things that we're starting to have more of an issue with is something that we're starting to understand. We used to have we still have a presumption of the market share is what gives you that power. We don't really care that much about the market. What we really are worried about is monopoly power. Do you have monopoly power? And there's two ways you're allowed to show that according to the Supreme Court. One is to define the relevant market and then figure out the shares. That's the standard way most of us do it. It's somewhat easier. And it's even easier because the Supreme Court has allowed us to make presumptions. So the Alcoa case, I have a slide here that's not showing up. Everything just froze. There we go. Well, now going backwards. This is learned hand in a famous case called Alcoa, and they were being charged with monopolizing a certain segment of the aluminum industry back in the 40s. And he comes out and he says, well, this percentage, 90% of the market that he defined, that's enough. I don't have to look any farther. They've got monopoly power. That constitutes monopoly with the sufficient power. There has been a question about this whole exercise ever since. You can see another case a little later. This is Justice Douglas. He says, yeah, tends to want to jump. The existence of power can stop jumping. You can infer this. Courts love these inferences. It makes their trials so much easier. The problem is they're just not very accurate, and they're super dependent upon what's the relevant market. If you take that Alcoa case, there were three possible markets that the judge was looking at. One of them, they only had 54% or something. Another one, they would have had 60%. And then the one they finally used was 90%. Well, the 50 and the 60s wouldn't have been enough. So the question becomes, is this a good measure? And there is a professor at the Harvard Business School who has been criticizing this method. He's been pretty strong in his criticism, and hopefully it'll show up. And I think he's right about this. Most people believe, this is a pretty flawed process. It is a shortcut that we use. We can't really define these markets that well, and it's gotten even more complicated. And he thinks we ought to just get rid of it. He's advocating that, economists and most people think that this is just not a good exercise. Now, he says, maybe we can come up with something better. And I think we will at some point with the new data analytics and find out, okay, do they have market power? Let's go look directly at it. This is out of an opinion from a judge in an antitrust litigation. This is a pharmaceutical case. I thought, well, pharmaceutical, at least you know what it is. It's kind of a drug. I think it should be easier to find the market. And this was his comment in that case. Yeah, he says, it's a confusing mess. And he says in pharmaceutical context, he says it really shows its warts. And I think that a lot of us do feel that way now. Now, I said there's another way of doing it. And you say, well, why don't they do it? And there's a little hint in Judge Rogers' discussion that she wanted to see something in this area. Epic just didn't put it forward. So one way is direct evidence of anti-competitive effects. Skip the relevant market and the presumption that this market share gives you that power. Go look for evidence that you couldn't have done this but for the power. And I think that's where we're going to probably trend to in a lot of these cases. Now, let me jump ahead. Another complication that's made all of our lives a little more miserable was a case in 2018 called Ohio versus American Express. And this had to do with two-sided markets. And if you haven't heard about two-sided markets, they're the thing with all these platform systems where we have an intermediary between two sides of the market. And we have to balance off what we're trying to get from one side with the other side. And the Supreme Court told us in that case, when you have a two-sided market with indirect network effects, that you have to look at both sides. You can't just pick one side or the other and say, oh, look, they got a lot of market share. You've got to look at both sides of that market. And if you think about it, the Epic case is a two-sided market. And in fact, we see that in the case. And there's a fair amount of discussion in the case about that. So just so you understand what we're talking about here, we have a platform. We have the App Store, and it controls two sides of that market. People coming in, if I want to get something on my iOS device, I go to the App Store. And a developer wants to get to me, a lot of them go to that App Store too. So we've got this digital matchmaker in the middle. Not much different than Uber, matching up drivers and riders. Not much different than a lot of people in the information age digital economy. And the court here did start, at least the litigants did start looking at this. They knew they had the Supreme Court case out there, and they had to offer up evidence. And these were the two-sided market evidence experts that were put up by the two sides. Both of these are very, very well-known people. And interesting, there was a lot of agreement between the two. A lot of that agreement, though, is that this is going to be tough to figure out. They came to opposite conclusions, but I think some of the statements made that were put into the opinion show you that, wow, this is difficult to tease out. So it's not clear that we understand the economics fully of two-sided markets. These two are the experts. And as you can see, the court, and this is from the opinion, talks about how there was agreement, but the agreement is this is complicated. This has effects that have effects on effects. And for us to try to tease this out cheaply in a trial, I'm not so sure we're doing any of this correctly yet. The interesting thing I find about these two, they wrote a book together. This must have been an interesting time. I actually have this book. And if you want to see a joint interview when they were promoting the book, take a look at the New Economics of Multi-Sided Platforms. So it must have been interesting that you got the two writing this book, arguing opposite conclusions from the research they've done going into their book. So that shows you that we really don't have a full understanding of what exactly is going on here. It's a little open to interpretation. As you know, this is what happened. Epic had to pay, and they had to cough up the 30% that they were siphoning off by not having the money come through the Apple system. They rejected the monopoly allegations. That's what Apple is looking at as the important part. But they did succeed in at least getting something under the California Cartwright Act that said, okay, well, you can you can have that in-app link somehow. But what does that mean if something else that happened later on happened? 2 days afterwards, Epic appealed. They obviously were ready for this, I think. Appeals are easy to do, but they quickly made that decision. But also, very quickly, they also had this exchange. These people kind of know each other a little bit. So Epic's CEO wrote to the senior VP, Phil Schiller, at Apple and said, hey, listen, okay, we'll pay up. We will, abide by the rules, but we're still going to appeal. And he tends to, Tim has been a little, I don't know, you might know Tim or something, but he tends to be a little aggressive. I mean, he runs a gaming company. What happens, though, is that Apple says no. In fact, he didn't say no directly to Tim Schiller, to Tim Sweeney. It was lawyer to lawyer. And let me go back one. This is the statement that's pretty brutal. Yeah, we're not letting you back on until the appeal's done and completely over. Okay, that could be a long time. This could be 4 or 5 years. Fortnite's looks like they won something. If your objective was to get on the platform, you're not on it. And can they do anything about that? Some people are arguing that shows market power. That's evidence of market power. Well, we'll see what that means. Tim Sweeney was not polite, I guess, and that's why I think this has gotten personal. That's why I think we're going to see this case go on. Oftentimes in business cases, sorry, this keeps jumping around. Oftentimes in business cases, they get settled before we get to a higher level court and get a decision. Now, companies don't want to go to the Supreme Court and get lawmaking. The ACLU might for constitutional issues, but we don't have businesses are making sort of hard decisions. You might ask if Apple's hard decision made it possible that Sweeney's going to say, yeah, we're going to take it as far as we can. I don't know if that's a good decision or a bad decision. One of the things I'd like to point out that, and I think Micky already talked about this isn't the only case that has the same exact problem. This market problem is in a lot of cases. Why is this going? So one of the other cases I'd like to talk about, and our state actually joined in on one of these, is FTC versus Facebook. And this is the judge in that case on a motion to dismiss. He actually said, I got a problem with this market definition thing. This is just not the way I see normal cases. It's not like he says tobacco or office supplies. It says what FTC, it's an enforcement agency that should know, what they're doing. They called it personal social networking service. It says, what is that? Everybody says, oh yeah, Facebook's got a monopoly. Monopoly on what? And I think that he made a very good observation when he made this one. He said, FTC, and these are, professional antitrust lawyers said, oh, they have a dominant share of the US social networking market in excess of 60%. They never said of what? 60% of revenues, of people, time spent on it. How do you even measure what a market share is on these platforms where I'm just going on? And the FTC didn't say. They have 60% of that market. What's the measure? This is the type of problem that we see. And I don't know if that's sloppiness or I'm not sure what you would use as the measure. What would be the legitimate one? So he also, I think this judge was smart in saying, the relevant market's not critical. It's the market power that's critical. But you can make that market power change by what I see as the relevant market. If Epic's relevant market is correct, then Apple's got 100%. If it's not correct and it's global gaming, it could be 30%. And I think that's where we've got to focus our attention, and we've got to start thinking, well, what is the right way of doing it? Now, the FTC filed an amended complaint. He gave them a chance to file an amendment. And on August 19th, they filed an amended complaint. And I was very interested to see, well, what market did they argue this time? They picked the same one. But what they did is they argued a lot about exclusionary effects. They added a lot of the stuff that Judge Wood was talking about. Forget about the relevant market. Try to show that they have a market power. Now, whether or not that's going to be successful, we'll see. If you look at that complaint, they excluded so many. It was almost, here's the market because these things aren't in it. And that's the way they sort of did it. So they excluded LinkedIn, they excluded Twitter, Reddit, and everything. YouTube, Spotify, Netflix. What else did they get rid of? A couple more. WhatsApp's not in it. And one more. TikTok, yeah. So, that's a sort of an odd way to define your market by what's not in it, without telling us, well, why aren't they in it? If you look at a number of these complaints out there, the Epic versus Apple, the complaint had essentially a single brand market. If you look at the FTC one, Utah versus Google, it's a single brand market. If we looked at Apple versus Pepper, which Supreme Court already has gotten just on standing, it's a single brand market. And I think this is going to be another area that's going to be explored. There are some instances, and the court even says this in Epic, where a single brand can be a separate market. And whether or not this satisfies that, the court here said they didn't. It came close, but they did not satisfy it. I'll just quickly point out, California has its own case. The major case at the Supreme Court is this Eastman Kodak case. And you have to do certain things and offer certain evidence. I don't want to go too deep into it, but I think that this will be something that will be explored because a lot of these complaints out there are single brand markets. And, we only have very light law in this single brand market area. So I think that we'll either flesh this out and have answers as to whether or not this is allowed. In Kodak, it had two factors that allowed that to happen. And in the new Cal case, which is out of the Ninth Circuit, they had a different idea. And it has, these are the factors, and this was the evidence. And the court's opinion was, you got 3 out of the 4. They didn't think that they got the last one. But that was close, a little closer than I would have thought they would have gotten on that issue. Okay. I think that the bottom line here is that this thing's not over. We don't understand the economics very well yet. We're still working on that. Making policy without economics and understanding what the implications are, I think is slightly dangerous. There are 7 proposed laws that are out there right now. I looked at it, none of them would solve this problem, but there are a number of laws that are proposed. I'm sure your company's following them and has been following them.
Actually,
9 now, okay. It's like
currently, yeah, and one of the things I think is interesting is that you don't see Elizabeth Warren and Ted Cruz agree on many things, but this is one of the areas where there's actually some degree of agreement. And that is, are the rules, so we have the various rulings, conducive, are the rules really conducive to how some of these companies are set up today? This isn't Exxon, this isn't Standard Oil from the 1920s anymore. These are really these two-sided markets where many of the products are free to consumers. Thanks. Where many of the products are free to consumers, yet there's an impact and a network effect associated with it that's downstream that is inhibiting competition. At least that's what a lot of the bills are being directed towards. And so I think this one's really interesting. Epic Games' sole focus is on iOS, ignores the market reality. If you recall Bill's slide a little earlier from green to red, on the one side of it when looking at what's monopoly power. I think you have to look at the economics of this. Apple's share, 55%, is on the richest 55%, right? The average selling price of a phone in the US is $280. So put that in the middle, right? Apple iPhones are 1,000 or more. So so that 55% is far on the right side, right? So where the money's actually being made is on the far right side. On the far left side is all the devices that barely do anything, right? You're not going to play an Epic game on a little flip phone. That's just not possible. So it's really only possible on this far end where the devices have that sort of processing power and graphics power and so on. So I do think this comes back down to the basic economics of it. But I'm still sort of baffled by how the market got defined as digital mobile gaming as the marketplace.
And by the judge as opposed to either side. Yes.
Right, which was even a narrower shaping of the market than what Apple was even arguing. Yeah. Since they were just saying it was video games in general. The one that threw it for me, somewhere in the 185 page opinion, they discussed other platforms on which mobile gaming can be used. And they mentioned Windows Phone. And so just having Microsoft background and knowing that Windows Phone, first of all, stopped making phones about 4 or 5 years ago and had less than 1% market share, yet it was cited in this case as part of the market. So that's sort of lost it for me as being, where is she getting this stuff from?
So it seems to me, and this might be what's going on here, the judge could have non-suited them for not, they had the burden, Epic had the burden, and she just said, you failed. Instead, she comes in and offers her own. And then if you look at that at 185 pages, a lot of it's just the facts. She's giving the appellate court a lot of stuff that they can look at because they can't do another trial, but everything in that opinion is possible to be examined. So it looks to me as that she knows this is going someplace.
Yeah.
And she's given them as much as she can as to what the findings are.
So we're not talking about this case, but there was an FTC Qualcomm case by Judge Koh in the Northern District of California that had a very favorable ruling on Apple's side that ended up getting turned over 9-0 in the Ninth Circuit. I wouldn't be shocked if this ends up in a similar way where the appellate level will take a much harsher look at what's going on here. But that will take years to happen, and in that amount of time, Apple will continue its 30% impact in terms of its share of revenues on the App Store, as well as not really complying. And by the way, this sort of tit for tat, not complying, happens all the time between these companies when there's when your phones are buggy, when your computers are buggy, and things aren't synchronizing properly. That's not always a quirk. Sometimes that's intentional, and it is a way of tweaking one company to another company. It's happened for years, and they'll continue to happen. You mentioned earlier, too, the distraction within Apple in terms of Tim Cook having to spend days on the stand. I think it's important to note Noreen Kroll, who's the head of litigation at Apple, was let go the day after the trial ended. And so one of the things Apple encourages their internal legal teams is to make law, is to take some risks and make some law in different areas. But I think that has its limit. And in Apple's case, in this one, I think the stakes were just so high. And the impact now it's having in terms of where this appellate court would land, what's happening in different countries around the world, this is probably something Apple should have settled privately, much the same way they did with Netflix, right? If Netflix, they cut a special deal and they're not getting that 30% cut, I'm kind of confused as to why they didn't do that with Epic here and just pay Epic.
Do you think it's because, it seems like Epic started this on a public in-your-face.
So did Netflix, so did Spotify.
Okay, but this was really
and Apple has ample money. So I don't understand why they didn't just pay this. I think it was a strategic decision where Noreen wanted to make a role.
There's something more going on.
Well, I think that there's areas where they want to actually make law. And I think they were hoping to preserve their 30% share in making that law here. And that it may end up being backfiring.
Yeah, at least part of it's gone.
Yeah, exactly.
We'll see how much longer. Anybody have any questions? Oh, we got a gamer back there. Is that AJ?
Nicholas Baker is on the webinar. He asks, is the market share ever looked at not just as what the company of interest has acquired, but the number of competitors in the remaining market? For example, Apple owns 55% of the market and the remaining 45% is owned by 20 different companies. To me, those other companies are too small to be able to truly compete with Apple, and a monopoly could be suggested. If, however, Apple owns 55% and one other company owns 45%, a competition remains and no monopoly exists.
Yeah, well, the other 45% is Google Android, right? Yes, it may be Samsung devices and a bunch of other devices, but it's really, there's two operating systems out there. And in terms of an app store perspective, there are two. There's the Google App Store and the Apple App Store. So that's one's 55, one's 45 in this country. Worldwide, again, it's 80-20, 80 Android, 20 Apple. And it's going to be a little bit different on a per country basis, sort of based on that price point and the price sensitivity that different constituencies will have. I don't know if you want to answer the question more directly.
Well, yeah, I think the whole problem is we have a lot of risks and uncertainties and things that could happen, futures that could and could not be. And I always liked this 5 forces of competition model that Mike Porter put out, even before he had two-sided markets. This is just a one-sided market analysis, and look how complicated we probably should be. We always just look at the industry being analyzed, with the relevant market, and we kind of stop there. Now, we do look at substitute products and services as potential entrants or as cross-elasticity man. If you start acting like a monopolist and raising the price, are these people going to start going someplace else? Then we keep defining the market. But I think you've got to look at buyers and suppliers now. I mean, what happens if you're selling to Walmart? Walmart's going to temper whatever you're trying to do in there. I don't care if you got a monopoly, you're selling to Walmart, they're going to be resisting that pretty well because they got a monopsony. And if your supplier has monopoly power, you're going to actually have a tempering effect there. What we're looking for is you have market power in that number one industry. I've got to at least look at these 4 others to get a handle on it. And I don't think we're doing as much of that as we probably should. Now, that makes a really expensive case. If we're suddenly looking at, you got to do all of that, is this possible even that private litigants are going to think this is worthwhile?
So I have a question for you, Bill, which is the difference between a vertically integrated company and a horizontal one as it applies to
both.
Or both. So Apple is vertically integrated, right? They sort of make everything. It's their own app store. They don't let it's a walled garden. They don't let anybody into their ecosystem. Just last week, in fact,
out of their ecosystem.
Sorry, out of their ecosystem.
Yeah, once you're in, you're in.
Once you're in, you're in, right? In fact, last week, the Europeans are trying to set a standard on connectors and mandating it being USB-C. The first company to complain was Apple, because they're like, "Oh, you're going to stop innovation in the physical connection market, and it's really going to be about accessories."
And they're the ones that have been driving it. We don't have VGA things on the side anymore. We have these little tiny things.
Right. Yeah. So I'm curious. Like Google is a horizontal, right? It allows lots of, as the pointed out, 45% is an Android operating system, but lots of different hardware manufacturers can come in and try to compete on that. Do you think there'll be any different analysis as we move forward? Facebook is vertical. Everything that happens in Facebook's world, you either choose to use it or not to use it. Do you think there'll be a difference?
Yeah, I think this idea of, in fact, this whole idea of the closed ecosystem came up in the opinion, as you remember. And I think that is that a legitimate business strategy? And if you're doing that, I need to be allowed to make it a closed system in some ways. At what point do you have to run into different rules? I thought some of the more interesting parts fit with the privacy, cybersecurity arguments that Apple was making, that we need to have this little closed world so that you have more secure apps. If we just threw it open to anybody selling anything, your phone wouldn't work half the time. So they're vetting and making sure that they have to go through the gate to get in, and that costs money. And they're just taking a toll. If you want to get into my garden, pay the toll. Is that a legitimate business model? Is privacy going to be worse or better with a system if we say, oh, you have to throw it open to everybody? Anybody can get in.
But is 30% the right number for that? And that,
right.
I think that's the question.
System,
is like, what is the right system? And should the government, should the courts have a role in determining what is the right profit margin that one should be getting here. So one of the things during this trial is Microsoft cut its app store, which is largely on Xbox and gaming, from 30% to 12% as a dig, right? They're not making much money on here anyway, but let's throw that data point out there saying, hey, you can make this down to 12, and 12 is plenty to vet and make sure that the apps and so on are secure. So should the courts have a role in determining what profit margin Apple should be
this was
getting?
always a problem I've had is industrial organization economics and the old classical model said that, oh, your marginal revenues, your marginal costs should cross at some point, and then that should be what your profits are, and anything above that's super competitive. Well, I don't think that plays out when something has huge fixed costs and almost zero marginal costs. I mean, what does it cost to have the next person sign up and buy another widget on the App Store?
Right.
To Apple? That costs nothing. If anything, every person that adds comes to that App Store, it actually makes it cheaper for Apple.
Which is why software has always had these phenomenal PE ratios, right? Like I know on Microsoft products, the profit margin is over 85%. Because for that same thing, the scale, when all the costs are one time,
millions,
then it scales on all the buyers.
Yeah. And I don't think economists take this into account, but should I take into account? So classical economics, if you do the marginal costs, you should include a percentage of the full costs. Well, I have a lot of failed products. Do I put a percentage of those in that marginal cost? Because companies make a lot of mistakes, as Microsoft has found it, very expensive mistakes.
Yeah.
Do those go in?
Drug companies in particular. Right.
Yeah, I mean, so it's easy to say if I have, and the models you learn in college and so on, they'd have one product. Yeah, okay, you put all the full costs back into them. How much of this cost of this case gets applied to other products in the Apple world? Or do we all assign all those costs to this? Right. Well, then that 30% might not be paying for this at all.
Exactly.
So
we may have time for one or two more questions if folks have any. Yeah.
One more from the webinar. Abraham Weber, what are the larger ramifications for the non-gaming market with this opinion? Could this broaden to other two-sided markets like credit card merchants, Salesforce marketplace, et cetera?
Yeah, so I can talk to this a little bit. I did talk to a former boss of mine who's a general counsel of Spotify after this case went out, and he was just sort of livid. He just could not believe that the court landed where it did in defining the market so narrowly and therefore cutting Spotify out of any sort of resolution here. Spotify is pursuing this more in Europe, where it's deemed to be a bit more friendly towards the Spotifys of the world than the US. But he fully expects there to be an appeal level here.
Yeah, and I think that sometimes we don't see that companies evolve. I mean, is LinkedIn now essentially a communication system? When it first started, I wouldn't use that for emails, but now that's a communication with some of my friends from other business things, or that's where they are. I'm not on Facebook, but I'm on LinkedIn. I think the Spotify, some people, wow, we're sharing the music. The next thing they know, there's it becomes a social network of some sort. Well, the problem with all these markets, they're not so easily defined. They're like if we said branded cola is a market, some of you would go, well, I don't drink branded cola. And in fact, if it goes up 2 cents, I'm buying something else. Some of you would, if Coke goes up $1, you're still buying Coke. So, that's the problem with all these markets. We've got lots of different people in them. And then we're trying to call it, well, here it is. It's
right. And where I'm drawn on the Apple side of the argument is to take this to the physical world, right? If you have a product on the shelf at, say, Walmart, should the company with the product be allowed to say what profit margin Walmart should get on that product, right? That's sort of the equivalent of what Epic is arguing here is like, I should get more of a share. The fact that it's on a Walmart shelf, and Apple saying doesn't have to be on a Walmart shelf. You can go to whatever other store and put it on your shelves there.
I mean,
no, go for it.
I should refer to the dean, of course. Okay, the one thing I think that we will need to explore that Europeans seem to like a little bit more is this idea of essential facility. Have any of these things become an essential facility, and should that be something that's recognized, where then you have to give me access in some way? Perhaps do something and act a little differently. We're not there in this country, but the Europeans seem to be pushing a little
Yeah,
harder.
but I go back to economics there, right? There's a lot of home court advantage here. First of all, there are like no European companies left.
Okay.
So they're regulating U.S. companies with this and trying to
So the essential facilities
revenue associated with it, right? Northern District of California, very, Cupertino's backyard, very favorable ruling for what's in for what's good for there. Same as what Judge Koh's decision was in FTC Qualcomm. So I think a lot of that plays out from.
So what happens when Europe
companies
says,
are.
"Oh, it's an essential facility, you got to let us in"? Are we just going to end up with the U.S. internet and that's it?
Yeah, so flipping to the patent side, some of the biggest patent holders in the wireless space tend to be companies like Nokia and Ericsson, and European courts are very friendly towards strong patent rights associated with those sorts of companies. So I do think a lot of it has to do with the home court advantage and domestic companies within its rulings.
So what do you think? Should we let the dean ask a question here? I think it's important.
Probably.
I promise it's a short, I just want to say, we are so lucky to have you guys talking about this. It's fascinating. And I just was wondering, in sort of a lightning round question, what's your prediction? What do you think is going to happen sort of long term?
Long term. I do think that we will get some more insights from the appellate court. I doubt it'll get to the Supreme Court. I'm not sure they're ready for this yet. But I do think our system is an inductive system that works from the bottom up. We need a lot of court decisions for, this, and people try out ideas and say, okay, this works, doesn't work. I think they're going to look a little harder at the market.
You think it'll go the way of the Qualcomm case?
I'm not sure a 9-zip is where it's going to go. I think this has a little more pieces to it.
I think antitrust case moved at a glacial pace. The antitrust investigations of Microsoft in the 90s and 2000s took 15, 20 years for it to resolve. And so in that amount of time, market dominance sort of continues and players continue to do what they do. That's a win, right? The fact that you're spending, $1 billion a year in court fees doesn't matter. It's a win because you get to keep what you're doing for the next 10 or 15 years.
But does it temper it? I mean, that's the question. Like people said that IBM got tempered a bit. That's why they let Microsoft get in on the PCs, because they were worried about the investigations and their dominance in computers.
And that's always been the case, right? So, I mean, in Apple's, just before the iPhone, Microsoft was loaning money to Apple to keep it alive because they needed another operating system that was out there, in the same way that IBM let Microsoft in the door. I've heard from Google privately saying, if you really want to hurt Google, shut Bing down, because then you have no competition left in the Google search, and then Google will get some of the same.
Then it will be a single brand market.
Exactly. So I think there's always this level of keeping things afloat to a degree, to show that there is some competitive forces still out there.
But there has been some change by competition activity. I mean, Apple has had to change some of their activities.
Right, and actually before this ruling, they came out voluntarily and said that they will allow for these sorts of in-app purchases, which is another reason why I think Apple sort of saw the writing on the wall and decided to go ahead and do this just prior to the decision. So I think they won this case really through the market definition. Apple gets to keep doing what they're doing.
And it's hard for me to see how all this legislation that's running around would solve this market problem. You can't change the economics just because you pass a law. And I think we've got to understand the economics better.
Right.